Articles 10, 27, 41, 43, and 47 of the Constitution of Kenya and the Task Force on Building Bridges Unity Advisory be compelled to publish a fresh amendment bill to include the same. B. A declaration that the IEBC be prohibited from conducting the preparatory process towards the approval of the amendment bill and submission of the same to a referendum. C. An order that Parliament be restrained from receiving and passing the amendment bill. The third petition was E400 of 2020, Third Way Alliance Kenya versus Steering Committee of BBI and others. The substantive issue raised by the petitioner was whether a popular initiative for the amendment of the Constitution of Kenya can be commenced by state actors, in particular the President of the Republic of Kenya. The petitioner further argued that a popular initiative in the amendment of the Constitution cannot be commenced and undertaken without a legal framework for the same. The petitioner sought the following reliefs. A declaration that the Constitution of Kenya Amendment Bill 2020 was not a popular initiative towards the amendment of the Constitution of Kenya. B. A declaration that there is no legal framework to undertake an amendment by way of a popular initiative, to wit, collection of signatures and their verification and conduct of a referendum. And C. A declaration that county assemblies have the power to amend the amendment bill, do not have the power to amend the amendment bill. Number 4, petition E401 of 2020, 254 Hope versus the National Executive of the Republic of Kenya. The petitioner herein urged the court to determine whether the National Executive or any state organ or entities can commence a popular initiative for the amendment of the Constitution of Kenya and utilize funds in the initiation and pursuit of the process. It is sought the invalidation of the entire process, resulting in the publication, approval, and passing of the amendment bill. The fifth petition was number E402 of 2020, Justice Juma and Isaac Ogola versus the Attorney General and others. The petitioners raised the question whether the creation of 70 constituencies by the by the promoters in the amendment bill was unconstitutional, since the function of the limitation
satisfy your cravings. Order all your
ayino mukuri gazi asumuchu Nairobi na nini gutete kuika Nairobi NCM ya mambia wikire gazi bono buke tiketi yao na mwamugusi travelers chikari chekinire asorogendo ruya na bono mkwenda na turichi service au kero kinero taitegari kwenda umusafara egari kwenda inyangi na boigo family vacation gose kwaruri South Africa kwaruri America kwaruri Qatar tobwa tigari kuranjukana matuko abiri atatu. Contact Mwamogusi Travelers. Nyole as number yesini 07 26 17 3003. Wosi as number ya kabiri. Enugo Isano na ibere. Eyemo Isato Kianda Isano Ibere. Isano na ibere. Mwamogusi Travelers.
Following the declaration of its unconstitutionality for want of enactment of the 2/3 gender laws and the advisory opinion by the Chief Justice to the President for its dissolution. The petitioner prayed that the court declares as unconstitutional and invalidates the entire process, culminating in the publication of the amendment bill. Petition number 7 was E426 of 2020, Isaac Aluchier versus Uhuru Muigai Kenyatta and others. The substantive question raised by the petitioner was whether the President has power to initiate an amendment to the Constitution of Kenya in the manner relating to the amendment bill and to use public funds in such a process. He contended that the steering committee had converted an illegal presidential constitutional change initiative into a popular initiative. He sought a declaration on unconstitutionality and the invalidation of the entire process. Worthy of notice is that this petitioner sought certain declarations against the president in his personal capacity. And the last petition was number E2, it was number 2 of 2021, Muslims for Human Rights, Muhuri versus Independent and Electoral Boundaries Commission and others. The main contention by the petitioner was that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place, and sought a declaration to that effect. I'll now summarize the responses to these petitions. The Attorney General filed grounds of opposition, raising a total of 12 grounds, which I shall summarize as follows. He stated that a declaration that the Constitution, the provisions founded under Article 255(1) of the Constitution forms the basic structure, entrenchment clauses, and eternity provisions of the Kenya Constitution and cannot be amended under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution would be against the express provisions of the Constitution, including Article 255(1), which will have been rendered odious. He added that the petition did not meet the established legal threshold of justiciability for want of ripeness, that the interpretation propounded by the petitioner runs contrary to the constitutionally prescribed purpose mode of interpretation by negating express purposes of Articles 255, 256, and 257 of the Constitution, and that any comparative analysis of foreign jurisprudence could not be used to either contradict or supplement the text of the Constitution of Kenya, that the petitioners were invoking an advisory opinion jurisdiction which the High Court cannot give. The Speaker of the National Assembly, who was the second respondent, raised 9 grounds of opposition. He concurred with the arguments advanced by the Attorney General with regard to justiciability and ripeness. In addition, the Speaker of the National Assembly contended that the petitioners were preempting how the National Assembly would exercise its mandate with respect to the amendment bill, and that the issues advanced could have been tabled before Parliament during public participation exercise as envisaged under the Constitution of Kenya 2010 and the standing orders of the House. The second respondent further argued that the High Court lacked jurisdiction to intervene in active parliamentary processes, and therefore any challenges to the amendment bill had to await the completion of the legislative process before the jurisdiction of the courts can be invoked to challenge the bill. The Speaker of the Senate, who was the third respondent, also filed grounds of opposition, raising 8 grounds. He reiterated the grounds argued by the Attorney General and the Speaker